December 1944. A regimental court-martial proceeding takes place inside a damp, stone schoolhouse near Metz, France. The winter air inside is cold enough to turn breath into white mist. 6 American soldiers sit on a wooden bench, their uniforms clean, their faces fixed straight ahead. They are here to tell the truth about what they saw on a muddy road just 3 days ago. They watched a white officer lift a heavy rifle and smash it into a man's face. But their words will never enter the record. The presiding military judge shuffles his papers, looks over the bench, and strikes their names from the witness list. He declares their eyes invalid before they can speak a single word. He rules that their testimony is mathematically useless because of their skin color. It is a quiet execution of justice inside an American courtroom. But this manufactured silence will soon reach the desk of 3rd Army headquarters. This is the story of what happened when a military judge tried to erase the truth by erasing the black soldiers who saw it, only to find General Patton rewriting the rules of his own courtroom. Before we continue, make sure you subscribe to the channel. We tell the World War II stories that show the moments that forced people to face what they had done. Corporal Benjamin Okafor was 24 years old and came from the crowded streets of Harlem, New York. He served in a quartermaster truck company attached to the 3rd Army, moving tons of ammunition and fuel through the freezing rain of the European theater. Back home, he had spent his youth working in a neighborhood print shop, saving every spare penny with the hope of one day opening his own business after the war. He enlisted because he believed that serving his country would finally earn him the basic respect he was denied in the civilian world. He had survived the mud of Normandy and the chaotic race across France, proving his endurance daily on roads targeted by enemy artillery. Now he sat on a low cot in a medical tent, his face wrapped in thick white gauze, completely unable to speak. A heavy steel wire held his shattered jaw firmly in place, forcing him to take his liquid meals through a thin paper straw. His physical world had shrunk to the rhythmic sound of his own labored breathing and the memory of a sudden, brutal blow from a wooden rifle butt. Major Allen Crawford was 44 years old and had been a successful corporate lawyer in Reno, Nevada, before receiving his military commission. He ran his courtroom near Metz with absolute precision, wearing a flawlessly pressed uniform and high gilded boots that never seemed to collect the local mud. Crawford believed firmly in the old social order, maintaining a rigid philosophy that wartime emergencies required the preservation of traditional hierarchies above all else. He had already presided over 2 previous court-martial cases involving white officers and black enlisted men. In both instances, he had used his legal authority to exclude every single black witness who attempted to testify against a white superior. He developed a personal legal theory, which he wrote directly into his official records, stating that testimony from members of an aggrieved racial group possessed an inherent bias that made it legally unreliable. He never applied this manufactured metric to white soldiers testifying against minorities. To Crawford, the courtroom was not a place to discover facts, but a tool to protect the authority of the uniform he wore. By December 1944, the European theater had dissolved into a brutal, frozen grind. The initial euphoria of the summer advance across France was gone, replaced by the grim reality of the winter campaign along the German border. Allied forces faced severe logistical strain, congested supply lines, and mounting casualties. Near Metz, ancient stone forts and relentless mud slowed the infantry to a crawl. In this high-pressure environment, divisions relied completely on quartermaster truck units to keep combat operations alive. Black soldiers worked around the clock, driving heavy vehicles over icy, mined roads to deliver ammunition directly to the front. Yet, these men lived in a strictly segregated military system. They performed the most hazardous logistics duties while being subjected to the rigid, discriminatory practices of the era. Military justice in the field was often swift, but it was far from uniform. Many senior officers chose to look the other way when friction occurred between white superiors and black subordinates. Maintaining the appearance of unity and preserving command authority frequently took precedence over investigating internal misconduct. In the chaotic environment of the winter advance, secondary legal matters were routinely dismissed, downplayed, or handled through backroom agreements to avoid official scrutiny. A white officer who crossed the line could often rely on the unspoken protection of peers who viewed discipline as a one-way street. This systemic negligence allowed small abuses to fester into severe violations of regulations. For months, paperwork disappeared, complaints were filed away in footlockers, and victims were quietly transferred to other sectors to keep the peace. The court-martial system inside the schoolhouse near Metz had become a shield, operating under its own isolation, entirely detached from the actual rules of the United States Army. The formal complaint sat on a rough wooden desk inside the headquarters of the quartermaster truck company. Captain Thomas Miller, a 32-year-old officer from Columbus, Ohio, adjusted his spectacles and looked across the table at Major Crawford. Miller held the official written statements of the 6 eyewitnesses who had seen the assault on Corporal Okafor. He placed the pages down squarely, tapping his finger against the top sheet. He stated that the regulations required these statements to be formally entered into the record of the court-martial immediately. Crawford did not look up from his ledger. He flipped a page, smoothed it down with his thumb, and told Miller that the matter was already concluded. He said the case was closed because there was no credible evidence to support the charge. Miller leaned forward, his hands flat on the desk. He reminded the judge that 6 American soldiers stood on the road in broad daylight and watched the entire incident from less than 10 yards away. He said their accounts were identical, detailed, and completely uncontradicted by any physical data at the scene. Crawford finally raised his eyes, his expression completely blank. He told Miller that the witnesses he was referring to were members of the exact same racial group as the alleged victim. He stated that under the legal standard he had established for his sector, such individuals possessed an inherent emotional investment that invalidated their objectivity from the outset. He called their observations legally non-existent. Miller asked if the court had applied that same standard to the white officers who had testified in defense of the accused. He noted that those men belonged to the same social circles and units as the defendant, which would suggest an identical potential for bias under the judge's logic. Crawford stood up, adjusting the smooth leather belt around his waist. He looked down at the captain and stated that his ruling was final. He said the white officer had been honorably acquitted due to a total lack of verifiable evidence. He told Miller that any further discussion of the matter would be viewed as a direct challenge to the authority of the court-martial tribunal itself. He ordered the captain to return to his logistics duties and leave legal theory to qualified jurists. Miller realized the barrier in front of him could not be broken through normal channels. He gathered the rejected witness statements, placed them back inside his leather portfolio, and saluted stiffly. He walked out of the schoolhouse into the cold winter rain, straight to his Jeep. He drove directly to the division command post, bypassed the local staff, and submitted a formal administrative appeal regarding the illegal exclusion of evidence. The report reached Patton within the hour. Patton arrived within the hour. His open-top Jeep pulled up directly to the stone entrance of the schoolhouse, the cold engine idling with a low, metallic rattle. The 4 silver stars on his helmet caught the dull winter light, and the twin ivory-handled revolvers rested against his hips. He walked into the courtroom unannounced, his boots striking the floorboards with a heavy rhythmic thud. The entire room went dead silent. The clerks stopped typing. The guard at the door snapped to attention, and Major Crawford immediately rose from his bench, his face tightening as he saluted. Patton did not raise his voice, but the chill in his tone filled the room. He looked at Crawford and asked if the major had authored the legal ruling regarding the incident on the Metz road. Crawford answered that he had, stating it was his duty to maintain the legal integrity of the court-martial panel. Patton asked how many American soldiers had been present on that road to witness the assault on Corporal Okafor. Crawford replied that 6 men from the quartermaster truck company had claimed to be present during the altercation. Patton asked if those 6 men had been permitted to raise their right hands, take the oath, and state what they saw under the light of day. Crawford answered that they had not, explaining that their testimony had been officially excluded from the record to protect the panel from inherent emotional bias. Patton stepped closer to the bench, his eyes narrowing as he took a sheet of paper from his pocket. He read Crawford's invented standard aloud into the cold room, noting the exact words that claimed testimony from members of an aggrieved racial group carried an automatic invalidity. He looked up and told the major that he had searched through the entire volume of the Articles of War and found no such regulation. He stated that Crawford had written a private rule which declared that a black man's eyes ceased to function the moment he stepped inside an American military courtroom. He noted that while Corporal Okafor lay in a medical tent with his jaw wired shut, unable to speak, the man who broke his bones walked free because the court chose to blind itself. He told Crawford that an army could not fight, advance, or survive if its officers subverted the very laws they were sworn to uphold to protect a criminal. He stated that a judge who fabricated regulations to keep the truth out of a record was no longer a judge, but an accomplice to the violence. He gave the major 10 seconds to produce the specific Army regulation that authorized the silencing of those 6 witnesses, or face the immediate consequences of his actions. Crawford stood entirely frozen, his mouth open, unable to offer a single word of defense. The verdict was delivered on the spot, shifting the weight of authority back to the written code of the Army. Patton did not wait for an appeal or a higher review, ordering an immediate retrial to begin inside the very same stone schoolhouse before the sun could set. He stripped Major Crawford of his judicial authority with a single signature, removing him from his bench permanently. The 6 black soldiers from the quartermaster company were marched back into the courtroom, where they finally took the stand, raised their hands, and spoke their testimony into the official record. Under the cold light of the room, their words re-established the timeline of the assault with undeniable clarity. The white officer who had wielded the rifle butt sat in the center of the room, his uniform offering him no further protection as the evidence piled up against him. He was stripped of his rank, convicted of assault, and sentenced to hard labor. Crawford was forced to sit in the back row of his own former courtroom, watching the proceedings as a silent spectator, while his invented legal metrics were erased from the record books. The room smelled of wet wool and wood smoke, and the local officers watched the rapid reversal in absolute silence, realizing that the old insulation of the sector had been completely dismantled. Corporal Benjamin Okafor survived the bitter winter of 1944 and saw the end of the war in Europe, returning home to Harlem, New York. In the autumn of 1945, his jaw eventually healed, though the deep scars along his jawline remained highly visible, and he carried a permanent stiffness that made chewing solid food difficult for the rest of his life. He utilized his military discharge pay to purchase a small, independent printing shop on 7th Avenue, operating the machinery himself and building a quiet, stable life within his community. He married, raised 3 children, and remained an active member of his local veterans organization, though he rarely volunteered detailed stories about his time in the European theater. He died quietly at his home in May 1988 at the age of 68, remembered by his neighbors as a soft-spoken man who demanded precision in his work and absolute fairness in his dealings. Major Alan Crawford never returned to a military courtroom or a position of legal authority for the remainder of his natural life. Following his permanent removal from judicial duties by 3rd Army Headquarters, he was reassigned to a remote administrative depot in Western England, where he spent the final months of the war processing supply manifests and equipment requisitions. He left the service in late 1945 and returned to his private corporate law practice in Reno, Nevada. But his professional standing had been severely compromised by the official reprimands in his military record. He lived out his remaining years in relative obscurity, maintaining a bitter resentment toward the wartime leadership and refusing to attend military reunions or public commemorations. He died of a stroke in October 1971 at the age of 71, leaving behind a collection of personal journals that still defended his invented courtroom metrics until his final days. General George S. Patton never made any mention of the schoolhouse trial in his public briefings, press conferences, or post-war memoirs. He viewed the entire incident not as a social statement, but as a routine enforcement of military discipline and a necessary correction of a broken command structure. He kept the original investigation files and Crawford's rewritten standard locked inside a personal footlocker at his headquarters until his death in December 1945. In a private letter written to his wife just 2 days after the incident, he noted briefly that an army could not advance if its judges were permitted to invent private rules in the dark. Some historians have argued that General Patton's rapid, heavy-handed intervention in the court-martial near Metz was driven primarily by an overriding obsession with absolute discipline and mechanical efficiency within his logistical network, rather than any modern sense of racial egalitarianism. They suggest that he viewed any subversion of military regulations as a direct threat to the tactical operational capability of the Third Army advance. Other historians argue the exact opposite, maintaining that his decisive actions represented a clear, unambiguous defense of universal military law that effectively cut through the systemic prejudices of the era to protect individual soldiers under his command. What is certain is that the official reversal permanently established a critical legal precedent within the European theater, ensuring that the manufactured standards of local commanders could never again legally supersede the explicit statutory codes of the United States Army. If you had been in General Patton's position inside that cold stone schoolhouse, would you have taken the same hard line against a fellow officer? Or would you have chosen a softer alternative to preserve the appearance of unity within the command structure during a critical winter offensive? Let us know your thoughts in the comments section below. And if you want more deeply researched World War II stories about the moments that forced people to face what they had done, make sure to subscribe to the channel right now so you never miss a new narrative.